11,000. 11,000. That's how many times people have tried to change the US Constitution. Clearly, a lot of Americans have thought it could use some work. But despite 11,000 attempts, only 27 changes have actually been successful. They're called amendments, and thanks to amendments, we have things like freedom of religion and press, the right to bear arms, and votes for women. We made alcohol constitutionally illegal, and then turned around and made it legal again. So, it seems like the Constitution should and does change along with American society. You might even say it's a living document, right? Well, that's what some believe. Others think that the Constitution is a locked document, or dead. And the conflict between these two sides can be confusing. Our country uses the Constitution to decide the legitimacy of laws. So we're left wondering, should we consider the Constitution to be living or dead? To answer that question, let's turn to the people whose whole job is to interpret the Constitution. This is the Supreme Court. 9 justices, appointed by the president, confirmed by the Senate. These folks are serious. I mean, just look at those robes. Their job is to interpret the Constitution and other laws in major court cases. But justices don't always use the same approach. Everyone has their own judicial philosophy. In other words, how they understand and interpret law.
You have to use some kind of method. I mean, you can't just come to a case and decide each case by how you feel today.
We asked Michael Schein, a lawyer and former professor of American legal history, about 2 of these philosophies: living constitutionalism and originalism.
The living constitutionalists believe that the overriding original intention of the framers, the big intention, was that they would create a framework that could grow and change over time. An originalist essentially believes that the only truly objective and nonpartisan way to interpret the Constitution is to find out what the framers originally intended the provision to mean.
Okay, to recap. A living constitutionalist says we should approach the Constitution as a document that changes with our society. On the other hand, originalists say we should look at the Constitution according to how the framers established people's rights over 200 years ago. Justice Antonin Scalia once said, "The Constitution is not a living organism, it is a legal document. It says something and doesn't say other things." Think about it like this. Say 5 years ago, you signed a contract to buy a house. But today, aliens invaded Earth. Should the contract still mean the same thing? An originalist would say, yep, you still have to pay your mortgage despite the UFOs. A living constitutionalist would say, let's take a second, look at the contract, and hey, try not to get vaporized. Both philosophies try and look at the contract and adhere to its meaning, but one takes into account what's going on today, and another takes it literally and tries to determine what it meant when it was written. But is it even possible to decide exactly what the framers meant? All right, let's look at an example. District of Columbia v. Heller was a case in which the court considered the issue of gun rights in America. The case asked, should individuals have a right to own and keep handguns in the home? At the time, D.C. had some of the most strict gun laws in the nation. All right, hold up. U.S. citizens have had gun rights since the Second Amendment was added to the Bill of Rights in 1791. But the question in Heller was, do citizens have a right to bear arms? Or is it more like a privilege that can be given or taken away by the government? Well, this shouldn't be too hard. Let's take a look at the Second Amendment. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Wait, what? I'm confused. Is it just me, or is the Second Amendment written poorly? Just look at all those commas and clauses. What's the most important part? The part about militias? Or the rights of the people? Well, that's what the Supreme Court was trying to figure out. All justices look at the language of the Constitution, trying to figure out what the framers meant. But they reached different conclusions based on their different judicial philosophies. Both living constitutionalists and originalists looked at the language of the Second Amendment and came to different conclusions. Living constitutionalists, like Justice John Paul Stevens, said that the phrase, "a well-regulated militia," was the most important part. But in opposition, originalists, led by Justice Antonin Scalia, said that the right of the people to keep and bear arms is actually the main idea of the Second Amendment. Believe it or not, D.C. v. Heller was the first time a Supreme Court had even considered a case that directly addressed the Second Amendment. Before that, no court had ever thought any law had violated it.
Hundreds of decisions and judges had relied on it, saying that the Second Amendment was limited by its language in the preamble to protect a right tied to militia service, not a personal right to bear arms.
In the end, the majority of the court agreed with originalists and Scalia 5-4. They said that the DC gun laws were too strict. Guns were important when the framers were around, and they're important to people now. But how does an originalist handle questions the framers never would have thought of, like affirmative action or same-sex marriage?
The fact that society changes and grows doesn't mean that what the framers originally intended by their language is irrelevant. But even so, no constitutional right is absolute. That's the point of the Constitution. It's supposed to last for the lifetime of the nation, which they knew would be beyond horse and buggy.
So, what do you think? How does it affect our democracy when justices separately consider the Constitution to be living or dead?